Chapter 4, we're talking about ADR, Alternative Dispute Resolution. Now, you may remember a couple chapters ago that I brought up the three key types of ADR: negotiation, mediation, arbitration. All right? In this chapter, it's discussed a lot more. And they do it again in the context of what we saw in Chapter 3, Northland Mining. And they bring up at least four different instances involving Northland and the business activities of Northland and the legal disputes that arise as a result of delinquent customers, hacking, pollution, and equipment breakdown. So review those, but let's get into the meat of what we're going to be discussing with ADR. First, negotiation, bottom of page 70. It's all about problem solving with negotiation. It's two or more people sitting across a table from one another and talking out their issues in the hopes that you can come to a private settlement of whatever disputes that you may have. When to negotiate is a key aspect. Is it going to be beneficial to negotiate sooner than later? It might be. Before the costs start to rise, you may choose to negotiate quickly because you don't have the time, the money, the energy, the emotional energy to actually put up with long-term litigation. So long as the person or the party on the other side is reasonable, you may stand a decent chance of trying to resolve this and moving forward. Something that always amazed me, and this, I'm thinking specifically about a case that I worked back in, 17 years ago. It was involving a large U.S. restaurant chain, and I was helping my law firm sue them on a class action level. We'll talk about class actions later in this chapter. We were suing them for race discrimination. Large, even larger now restaurant chain who we alleged and we believed and still believe were discriminating against their black employees. What always amazed me when I was going through this, they hired a very prominent, large law firm to represent their interests versus, effectively, there were 4 or 5 of us on the other side representing literally every black employee in the restaurant chain. And there were thousands of black employees in the restaurant chain. It always amazed me how much that company was willing to pay these lawyers. We never found out exactly. We could only predict what they were paying. They were probably paying millions of dollars over the course of the years that this suit dragged on for these lawyers on a suit where there was no guarantee of victory. And when you consider it from a cost-benefit analysis, wouldn't you think that it would have been much more beneficial to settle the suit out early rather than drag it out, pay your lawyers, only to have an uncertain result? It made no sense to me. We could have negotiated this early for pennies on the dollar, and yet the company decided to stand their ground, and ultimately it didn't even work out for them. Ultimately, they ended up paying my clients millions of dollars anyway, paid my firm's lawyers' fees, and ultimately had to change their direction so that they would have to hire and promote and pay their black employees in a much fairer way. Never made sense. Would it have been beneficial for them to negotiate early? The answer, I believe, to this day is yes. How to negotiate? Are you going to be hard-hitting? Are you going to try to scare the bejeebies out of whomever is sitting on the other side? Or are you going to come at it from a different tack? How to go about negotiation is going to be important. It depends on who you are and what the circumstances of each case are. You'll notice on page 72, with negotiations, the goal is to reach a resolution that is agreeable to all parties. That said, there's no guarantee that a settlement will be reached, and whether negotiations do succeed will depend on a number of factors, including the following: the willingness of the parties to compromise and negotiate in good faith, the nature and the significance of the dispute, the priority the parties give to its resolution, and the effectiveness of those involved in the negotiations. Page 72. Ultimately, if there is a settlement agreement, another word for a settlement agreement is a release, where it's an agreement to relinquish all past, present, and future claims arising from that certain event. A settlement agreement should be comprised of everything that might be part of this dispute, because the last thing you want is something coming back later. One of these parties coming back and saying, hey, you didn't settle this, I'm coming after you again. Settlement agreement needs to be comprehensive. It needs to be all-encompassing. It needs to be able to bring to closure these matters that are the subject of the dispute. We next go to when negotiations are ultimately going to end. Is there going to be an impasse where no matter what you do, there's no way in heck that you're ever going to come up with a negotiated resolution to a problem? And the only thing that's being achieved is arguably you're giving away information that you don't want to give away if you're involved in the litigation. If you come to impasse, negotiations are done. All right, you move forward. Could negotiations return? Maybe, down the road. But it's not going to happen now. Page 74. We get to mediation. We use a mediator. Why do we use a mediator? There are 4 bullet points toward the top of page 74. It's less expensive and it's quicker than even more formal dispute resolution methods. It's private and confidential. It helps to preserve the relationship between the parties and can result in a resolution tailored to the needs of the parties. It's cheaper. Now, a good mediator could charge several $100s an hour, but at the same time, say that you're negotiating for 8 to 10 hours. Are you going to be paying less if you're able to settle something then? And the answer is yeah. And plus, you don't have to pay your lawyers anymore. It's more private and confidential. You know what? It is. Everything that's done in a mediation room, with certain rare exceptions that you don't need to worry about here, are intended to be completely confidential. It's not as if you're going to be sitting on the stand testifying in a trial and the lawyer for the other side is going to say, and you did offer us $1 million to settle this suit during mediation. That's not what happens. It's completely confidential. Whatever goes on in mediation generally stays in mediation. It is the Las Vegas of ADR, okay? No worries, you can be open. Most of the time, the parties aren't even together. They meet at the beginning, and then they normally go off into separate rooms with their lawyers. And the mediator then shuffles back and forth between the parties, trying to come to something where there can be some agreement, there could be some settlement that's roughly drawn up to resolve the entire lawsuit. Mediation can help to preserve a relationship between the parties. Maybe, just maybe, these parties may have a dispute, but they'd like to continue to do business with each other. If you drag this on through litigation, the longer litigation goes on, the less likelihood there is that these two sides are going to want to have anything to do with each other. As lawsuits drag out, as parties are spending money, as there's more acrimony, more hostility building up over the course of months, years of going against one another, especially if each side's lawyer is being particularly aggressive in trying to vindicate their client's interests, then it's not going to preserve any relationships for the future. And again, with mediation, it's going to be tailored to help to resolve each person's case, where hopefully both sides can walk away saying, I didn't get everything that I wanted, but I got something. And I guess that's good enough. And at the very least, as a lawyer, I tell my clients who go through mediation this, at the very least, you could stop the emotional torture that sometimes occurs when you have to go through litigation. You can move on mentally and saying it's over. You have the closure. Closure is very important. Arbitration, page 75. Arbitration is used normally to resolve commercial and business disputes. Also, it's used prominently in labor dispute settings. In the event that when you're negotiating a union contract and there is an impasse during those types of negotiations, there's arbitration is called to be able to privately settle those disputes using an arbitrator, a sort of private judge. The idea, just like mediation, though, is to provide closure, but unlike a mediator, an arbitrator will decide the case. They will sit in judgment and decide which side wins, which side loses, what type of damages can be awarded, how the relationships, the pre-existing relationships might be tweaked in the event that they are to continue. That's what happens. And generally speaking, okay, the decision of an arbitrator is seen as being, unless they overstep to a great degree and their decision is so clearly wrong, the decision of an arbitrator is seen as being binding. If you try to challenge the decision of an arbitrator in court, which you can do, the likelihood of success is probably very slim. We move on to the litigation process itself, and this is just a brief overview of the parties to the litigation process. The person bringing, or the party bringing the lawsuit, is the plaintiff, or sometimes called the claimant. The person defending the lawsuit is oftentimes called the defendant or the respondent. I used the term defendant before. If you're suing, you're the plaintiff. If you're being sued, you're the defendant. If the defendant decides that he or she or it wants to sue the plaintiff, then the defendant becomes the counterclaimant or the counterplaintiff. At that point, if the defendant is now suing the original plaintiff is also known as the counter-defendant. And oftentimes you have two different lawsuits going on involving all the same facts in one single lawsuit. There is mention here of a limitation period. We also call it commonly a statute of limitations. And there is a Limitations Act here in Nova Scotia that sets how long a period from the date that you discover that there is a basis for that you have been injured, how long you have to actually file your lawsuit after you make that discovery. And here in Nova Scotia, based upon recent changes to the Limitation of Actions Act, most lawsuits in Nova Scotia, and I would strongly urge you to review that particular law, most of them are subject to a 2-year statute of limitations. That's the period you have to file the lawsuit. Just file the lawsuit. And that's critical. And as lawyers, we have various perspectives on whether that's enough time. In a car accident case, however, in Nova Scotia, it's subject to a 3-year limitations period. But generally speaking, almost every other type of lawsuit will be defined under the law that I mentioned before, the Limitation of Actions Act. Important concept here is a class action lawsuit. I referred to it just a few minutes ago when I was discussing that restaurant chain that I had helped to sue 17 years ago. Class actions are designed to represent a wide body of people who have common traits to what they're doing. In the case that I mentioned, these were all black employees of that restaurant chain, and they have similar issues. They were being the subject of discrimination. There is power in numbers. And not only that, it's a much more cost-effective way of bringing a lawsuit and trying to bring to a resolution the issues that are there. Could you imagine what would happen if you had a bunch of people, oftentimes who cannot even afford their own lawyer, trying to bring individual lawsuits against one company? That would be difficult. Plus, it wouldn't be very effective administratively for the court system to have to deal with all the same issues every single time. If you're dealing with a similar group of people with similar issues against a similar defendant or an identical defendant, sometimes you could be talking about hundreds, if not thousands, of individuals. The court system doesn't want to have to continuously relitigate the same issue over and over and over again. Class action lawsuits are a way to stem that, to hear everything at once involving one big class, and in that way also achieve major change, a major resolution to whatever those class action plaintiffs may be saying. So please pay careful attention to page 79 and the article with regard to class action lawsuits. You'll also see other examples on the top of page 80. And we get on page 81 to the stages of a lawsuit. When you file a lawsuit, you are filing what's called a pleading. Specifically, the type of pleading you're going to be filing is called a claim, a statement of claim. It asserts what the allegations are against the defendant. In response, normally within 20 business days, the defendant will file its own pleading. Normally, it is a statement of defense. At the same time that it files its statement of defense, it should also be filing, if there is an allegation that the defendant can make against the claimant or plaintiff, it can file what I mentioned before, the counterclaim. Page 82, discovery. It's the process of disclosing evidence to support the claims in a lawsuit. It's meant to be liberal. It's meant to be able to let each side see what the opposing side has got, what documents they may have. And it will force the other side to answer various written questions, what we call interrogatories. It will require the other side to answer what are called requests for admission. It will allow for actual oral discoveries, what I also call depositions, where one side calls a witness out and they can question outside of court that witness and swear them under oath and have a court reporter there to take down all the answers, and the lawyer can then ask almost anything unless it violates a privileged communication, or if it's just the lawyer badgering the other party or the witness. Generally speaking, oral discoveries, depositions, are intended to be wide and probing and to ask virtually anything or everything in order to be able to determine what the strengths and weaknesses are of both your case and the other side's case. Additionally, there's going to be motion practice where various motions, especially after the close of the discovery process, one side or the other may choose to file what's called a motion for summary judgment, saying that, okay, here are all the facts. And all the facts, once they're considered, do not give the other side a case that they can bring before a judge or a jury for factual determination. Once that's done, though, if a motion for summary judgment fails, then you have a trial. And on the bottom of page 83, we discuss trials. We discuss the burdens of proof on page 84, the evidence that's presented, and ultimately the decision or the verdict. Now, in small claims court here in Nova Scotia, if you remember from the previous chapter, those lawsuits that are brought where the total damage value falls below $25,000, the only cost that can be awarded, the only expenses that can be awarded are your actual costs. All right, for instance, if you have to issue subpoenas, if you have to pay a filing fee, your legal fees, the cost that you pay for your lawyer is not something that could be awarded back to you if you win in a small claims court. If you file the case in Superior Court, or again, what we call here in Nova Scotia the Supreme Court, your legal costs can be returned to you if you are successful in your lawsuit, which means the other side could ultimately be paying your lawyer's fees. Finally, well, almost finally, we talk about enforcement. If there is a judgment that has been handed down against one party, and that party doesn't do what they're supposed to be doing, paying damages, making changes, etc., then that judgment can be enforceable in court. And the court can order the person who is failing to follow the judgment to do so immediately, can also hold that judgment debtor, as you'll note on page 86, in violation and contempt of court. Finally, we deal with appeals. If you don't like what the judge decided, whether it was on a legal issue, principally on a legal issue, or even on a factual issue, in the event that no reasonable judge would have made those factual decisions, then you can bring an appeal. And you'll see that the names of the parties in an appeal are different. It's no longer plaintiff and defendant. It's now appellant, the person who is bringing the appeal, and respondent, the person who is responding to the appeal, the person who won down below in the trial court versus the person who lost, the appellant, in the trial court. And so you bring that to appeal and you ask normally a 3-judge panel to issue a ruling to reverse the decision that was made by the trial court and to sometimes even send it back to the trial court to take further action consistent with an appellate opinion. So that's really it for the litigation system. And again, this is just a very brief overview of what goes on. In this chapter, as you'll note, we've discussed alternative dispute resolution, and we've also discussed the litigation process, and we're going to get into, in your assignments, other questions. Thank you.